Bushu Anishinaabe, hello friends. My name is Elizabeth Kronk Warner, and I have the privilege of being the Dean at the S.J. Quinney College of Law. We come to you today from Phoenix, Arizona, where I'm very excited to be joined by many of our alums here in the room and even more of you online. So thank you for taking the time to meet with us today to talk about this really important topic. We've been chatting here in the room about just how much it's impacting our daily lives. And so I'm very excited that we have our expert with us here today and a wonderful alum, Dan Garrison. So Dan is the founder and CEO of Open Wallet, a company dedicated to providing innovative financial solutions that enable law firms to offer affordable payment options to clients. He is preparing to launch Smart Law AI, in an online education platform designed to equip lawyers with essential business schools under the model Smart Business for Smart Lawyers. I like it. Did AI come up with that?
No, I actually came up with that one.
Dan has 3 decades of experience as an attorney, a law firm owner, and fintech CEO. And he is adjunct professor at SJQ. He came and taught a boot camp for us over the winter break. And he teaches courses on law practice management and business planning. Through these ventures, he continues to drive innovation in legal practice management and client accessibility. And he earned his law degree very proudly at the University of Utah, where he was inducted into the Order of Coif and served on the Utah Law Review. Over the course of his legal career, Dan was privileged to receive an AV preeminent rating from Martin Hubdale and was named a Southwest Super Lawyer and Best Lawyer in America. He's also received state and national awards for his corporate restructuring work. So we are very pleased to have him here. And also interesting connection to our Dean of Career Development, Arturo Thompson, used to work for Dan here in Arizona. So
that's true.
We're all
close to 20 years ago.
Yeah, 20 years ago. Time flies when you're having a good time. So with that, I'm going to turn it over to Dan for today's presentation. I'll be sprinkling in the occasional question as we go along, but we're going to learn from Dan today. So Dan, take it away.
Thanks, Elizabeth. I LinkedIn wonderful, all those little details about the last 30 years of my life. Thanks again. My name is Dan Garrison. I want to kind of give an overall sense of what we're going to try and accomplish today right at the outset. We've only got an hour. And so I will tell you, I sat through a 6-hour online global symposium on AI yesterday that went at a lightning pace and only scratched the surface in developments. This is a topic that quite literally changes on a weekly basis. There are a number now of automated podcasts that deliver daily news on AI, generally in business and industry. One of my hopes is actually to launch a similar kind of a podcast for legal applications of AI. So we're going to kind of give a very high-level overview of ways in which AI can be incorporated into law practice. And then we'll do a little bit deeper dive in 3 use cases, which we'll talk about. As I get the PowerPoint up here, we'll jump to the second slide, which is our agenda. And I'll kind of walk you through the plan for the day. All right. Yeah, I guess I have the clicker. I can do this myself. All right, so the first thing we're going to talk about is just an overview of all the various opportunities that exist to integrate AI into a law business. And you'll see I use law practice and law business somewhat differently because one of the things I want to point out is that there are a number of applications of AI in the business of running a law firm. We're going to spend a little bit more time talking about AI applications in the actual practice of law. Our next topic is going to be talking about ethical considerations, and they are numerous in the use of AI, and we'll probably share some vicarious war stories of folks who've run afoul of those using AI inartfully. We'll then talk about using AI in legal research and drafting legal analysis, which is probably, I would say, the most common application out there currently for using AI. But then we're also going to spend some time talking about AI-powered tools in form-based legal practices, and then finally wrap up using AI-powered document review tools, both for litigation discovery and for diligence or contract review purposes. So let's just dive right in. I've tried to come up with a fairly exhaustive list of different ways that AI could be incorporated into a law business. And I by no means think that this is a complete list, but it gives you kind of an idea. Document review and analysis. I mean, any of us who are in either corporate diligence or in litigation practices understand the amount of time and effort that goes into reviewing huge quantities of documents, and AI has a real beneficial application in that area. Predictive analytics, everything from predicting outcomes of cases to predicting outcomes in the business of law, and kind of everything in between. E-discovery. So there are a number of tools out there currently, and they're constantly coming onto the market where AI can interface with your electronic communication systems, your document management systems, when you've got litigation holds in place and need to do discovery productions. This is a big one, and I will tell you, we're not going to spend a lot of time talking about this, but the marketing applications and the opportunities to use AI to enhance your ability to interact with clients and to manage relationships are absolutely huge. And I was talking to Elizabeth before we started today about my perception, which I think is accurate, that the business tools that are using AI right now are probably more mature than the tools that we're going to talk about that are specific to law practice management. And I think it's largely because there's a larger audience for those things and a lot more money, consequently, that are going into them. And I think all of us can probably agree, even if it's with a little chagrin, that the legal industry tends to be a little bit stodgy and slow to adopt technology. And so we tend to lag behind the rest of business and industry in the adoption of new technology. Automated legal research and writing, we've already alluded to that. We're going to talk quite a bit about that today. Legal analytics and business intelligence. There are great opportunities to bolt AI onto your data capture within businesses, throw Microsoft BI or another analytics tool on top of that, and really get down to the finest detail about what's happening in your business. Billable hour productivity, efficiencies, staffing models, a number of things that can happen there. Billing and timekeeping, picking up trends, missing opportunities. There are AI tools that are becoming quite robust in that space. Not going to spend a lot of time on that today. Regulatory compliance and risk assessment, and we'll touch on this when we talk about diligence and document review. And as I said, we're out of this list going to spend time kind of focusing on 3 particular use cases for AI technology. They are legal research and writing, form-based practices, and document review, both in litigation and in diligence applications. All right. So let's dive into kind of the first topic. And I chose this one first because honestly, as we'll discuss, it's sort of an overlay for everything that we're going to talk about today. And the ethical considerations for using AI are numerous. So let's just touch on each one of them that's obvious. So rule 1.1, and I'm referring to the model ABA rules. Obviously, we've got an audience that's across, I'm guessing, many states. You'll find analogs for all of these in your state rules of professional responsibility. But fundamentally, we have a duty to provide competent service to our clients. And AI raises questions in terms of human interaction and human involvement in the process about competence. Confidentiality is a big concern here, particularly where we're talking about open source, large language model, AI tools. Anything that you put out there is accessible by anyone with the skills able to data mine for it. And, you know, even in more closely secured kinds of models, there are real considerations about what you should or shouldn't put into them in terms of confidentiality.
Am I understanding correctly? Are you saying there's no way to block off client sensibility, even if I've heard of firms kind of creating, they describe it as a moat around their data, and then they can use AI. So if I understand correctly, you're saying even that is maybe not as safe.
Well, no, actually that, you know, I don't want to go so far as to say that solves the problem completely. There always needs to be a sensitivity, but let's talk about that for just a second. So I talked about sort of open source large language models, ChatGPT being the most known and visible one of those models. There is no castle and moat in that model. The castle and moat metaphor refers to the idea of being able to create secured space, a repository for what you want to put out there. So examples of LLMs that have a castle and moat structure, or at least can have, would be like Jasper or Claude. And the idea there is that once you set up your secure space, you can put sensitive information into it with a high degree of confidence that it can't be breached. Certainly the same level of confidence you might have if you had security on a server, an old school server. And there are some advantages to that too. We'll talk about those a little later in the conversation in terms of being able to teach your model and conduct uh, searches that are not stateless. And we'll talk about what that is within, say, a chat GPT model to make a contrast. So rules 5.1 and 5.3 are about supervision, sort of the same themes as competence. We want to be sensitive to the idea that a real attorney with an appropriate level of training and experience be involved in making decisions and reviewing information. And I will say on the supervision topic too, I perceive that there's a tendency, given the ease that these tools can be used, to push their use, their frontline use, down to relatively inexperienced and less costly attorneys. And that's a further implication of this need for supervision. Diligence. So kind of along the lines of competence, we've got a duty to diligently represent our clients and to diligently review information and the law and so forth. And that's implicated here strongly. So communication really comes up most commonly in marketing and client relationship management applications of AI. But we've got a duty to communicate robustly with clients, honestly, transparently. And AI tools, while they're very useful, can be something of a black box. If you're setting it and forgetting it, to use the vernacular, you're probably putting yourself in a zone of risk for violating Rule 1.4. Truthfulness in statements. This runs a bunch of different directions. We're going to talk about candor to tribunals too, and it kind of overlaps a bit with that. We were sharing war stories about attorneys that we know in the news have been sanctioned fairly recently for filing briefs with courts that had completely made up case citations in them. And for lack of diligence and competence and supervision, they violated also Rule 7.1 and the rules on candor to the tribunal by citing cases that literally did not exist for propositions that they obviously couldn't have stood for.
So even with all these tools, we still need to be double checking things.
Yeah, absolutely. As we talk about the pattern that's going to evolve as we kind of go through these three use cases will be pretty obvious. We're going to talk about the upside benefits of using them, and then we're going to talk about the risks and weaknesses that exist with their use in these particular areas. And then we're going to talk about strategies to try and mitigate those risks and provide better results. So continuing the list, prospective client communication. So this really leans into the marketing side of things and truthfulness, not overselling things and so forth. We've already talked about candor to the tribunal. Fairness to opposing parties really has to do with whether or not the systems you're using comply with the rules and whether, the productions that you're making or the products that you're holding out comply with applicable regulations and so forth. Safeguarding client information. We've already kind of talked about the castle and moat model, and the risks of putting out sensitive information in open source, particularly free, unregulated models like ChatGPT. And then informed consent, which goes to the heart of disclosing to your client that you're using AI, making sure that they're comfortable with that. Making sure that your use of it is consistent with their own internal policies, because we are essentially agents, particularly of our corporate clients, and they may have very detailed and thoughtful policies about how AI should be used, and by extension, we should be sensitive to that as well.
So it sounds like you're saying between Rule 1.18 and 1.0 that we have a duty to tell our clients when we're using AI.
Yeah, this has become a general rule of thumb, I think, that transcends the legal industry. That the best practice recommendation is that you should always disclose when a product has been created using AI, or when you're using AI in various stages of review, analysis, communication, and so forth. I will tell you, both based on my own and some vicarious experience, that the majority of clients that I've disclosed these kinds of things to actually regard it as a positive. It tends to portray you as a tech savvy, cutting edge professional And the disclosure tends to promote their trust and confidence that, you're disclosing it to them. So I can't really see any downside at all in not telling them, but on the flip side of the coin, I think there are real risks. Okay. So let's just lean into the first use case that I think most of the folks who are here and online watching the seminar have probably played with, and that is the idea of doing legal research, analysis, legal writing, using ChatGPT or potentially one of the very many now tools that are out there. And I want to at this point probably emphasize that I'm going to talk about particular tools, like we'll refer to ChatGPT a fair amount because it's the most commonly used one. Westlaw and Lexis each have their own AI-driven products. Clio does as well. And then there's some specialized, actually quite a large list of specialized legal research and analysis tools out there now that I'm not endorsing in any way and candidly haven't reviewed exhaustively. But what I'm going to try to do is give you some ideas about what to watch for and how to use any or all of them with a higher degree of confidence that you're getting good results and not violating rules. Okay, so let's talk about the benefits. And these are probably pretty self-apparent and self-explanatory. So AI is just incredibly fast at canvassing huge swaths of information in a matter of seconds or perhaps minutes instead of hours or days or weeks, depending on the project that you're talking about. And consequently, there are enormous cost savings potentially, both in terms of your operating expense as a practitioner or a law firm owner or manager, but also, in terms of cost that's being passed on in billable time to your clients. And all of us have heard the complaints from clients about the amount of cost that it takes to do legal research and to do document review, and everybody's bane is discovery and litigation and so forth. So huge advantages there. The second obvious one is thoroughness, because subject to the way that you query or prompt these AI tools, AI really looks at everything. In fact, the only way you can really stop it from looking at everything is to tell it that you only want it to look at certain things, which is one of the strategies that we'll talk about shortly in trying to mitigate the risk of hallucination and some of the other typical errors that AI commits. And then, the other thing, and this is probably a little more subtle, less obvious, but all of us have probably known and unknown confirmation biases that come to bear when we do research or we tackle a particular problem. The most obvious one of which is that we're typically trying to win something or prove something. And so we have a tendency to filter information through that lens of what is the best for the argument that I want to make or the point that I'm trying to win, the outcome I'm trying to achieve. And AI is just agnostic about that stuff. And so depending on how you ask it for information and to conduct analysis, AI doesn't care what the result is. Now, we will talk about one of the risks, which is sycophancy with AI, that it has a tendency to want to please you. But if you're asking it the right questions, it's going to give you an objective response. So let's talk about the risks. And there's a term that gets used in AI that is kind of a metaphor, and that is hallucination. And hallucination is the source, for example, of the situation that we were talking about where attorneys are filing briefs with cases that literally don't exist. And if you think about the breadth of the internet, and the good, bad, and awful information that's out there, it's not hard to imagine that an AI model might run across manufactured fictional cases in God only knows, what part of the internet, but it could be in fiction. It could be in teaching materials, all kinds of different ways that it can happen. But hallucination is basically it coming up with something that sounds true and authoritative, but is absolutely false. And it can be citations, it can be analysis. We're going to see some examples of that in the next couple of slides. The second big risk is what we call flawed retrieval. And that is really an error that comes out of it not finding or not pulling all of a particular type of information that you're looking for. And we're going to talk about retrieval augmented uh, generation models, which basically slap large language model functionality with a known database of information. So like LexisNexis and Westlaw are good examples of what we call RAG or retrieval augmented generation models. Scope or applicability of authority. I mean, we'll talk about this when we talk about prompt engineering, but if you don't tell it what's authoritative for you, it's not necessarily going to know that. You can teach it hierarchy of authorities, particularly if you've got your own castle and moat kind of model. But particularly the very wide, large language models don't understand the idea of precedence or jurisdiction and hierarchies of authorities. And so both from temporal and jurisdictional perspectives, AI is prone to making mistakes. And then I've already talked about the idea that AI wants to please you. And so those biases that you have that find their way into your prompts and your requests for assistance get redoubled by AI sometimes in terms of it wanting to answer the question positively for you. And so there are things that we can do to try and mitigate against it being a sycophant or wanting to please you. Okay, so I'm going to show you a couple of graphics which should shock you a little bit. And the citation on the second slide will tell you that this is from the Stanford Human-Centered Artificial Intelligence Project. And this is the result of a study that was published about 9 months ago in May, which in AI is actually an eon ago. But the studies can't quite keep up with the changes that are happening in the technology. And this is the most recent authoritative source I could find for this. But basically what this graphs for you is the incidence of 4 of the leading AI models. So Lexis's product, Westlaw product, Practical Law, and ChatGPT-4 coming up with hallucinated or incomplete results. And you can see there that the best statistic that exists is that GPT-4 tends to be pretty complete, but it's still coming up with incomplete results about 1 out of 10 queries. Practical Law was struggling still. I'm sure that they have improved since then, but because they are a retrieval augmented generation model, meaning that they're only as good as the universe of data that they are accessing, they tended to come up with incomplete results 60% of the time with test queries that Stanford used to assess this. The title of this study is actually on the second slide, and it is in the footnote, AI on trial, legal models hallucinate in 1 out of 6 or more benchmarking queries. That should give us all pause. So here are a sample of the input queries that were used to test these models and some examples of hallucinated, misinterpreted, incorrect responses that each one of those AI models generated. So you can see in the top left there, the input query was, are the deadlines established by the bankruptcy rules for objecting to discharge jurisdictional? And Westlaw provided a response with a citation to the Federal Rules of Bankruptcy Procedure that said that they are jurisdictional, and that is just flat out incorrect. Now that one's subtle. You'll see some that are far less subtle. You can spot immediately that they're wrong.
Yeah.
That one you could easily make a mistake with, right? It looks authoritative. It has a direct citation to the rules. And so unless you went back to the rules and went to an annotated guide and looked at some of the case law yourself, you wouldn't know that one. Let me give you an example of one that is obvious. So in the bottom left, you've got an input query to Practical Law. What did Justice Ginsburg, why did she dissent in Obergefell? Which I think, as we all know, is a very different decision than the one that is described here. So Practical Law came up with an answer that was based in copyright law and the Copyright Act. I mean, that one you wouldn't typically make a mistake on, because if you're asking about the dissent in Obergefell, you would know that that was a completely spurious response. The other two are kind of in between. I think they probably would be spotted as spurious. The bottom right one probably a little less so. But again, these are the kinds of things that we have to be sensitive to. Now, when we start talking about prompt engineering, I think you're going to get a sense as to how these particular prompts could probably have been engineered better to mitigate against these risks. But as of 9 months ago, Stanford benchmarked these tools, which are arguably some of the leading tools out there, and found a fairly high incidence of both hallucination and incomplete responses when compared against traditional human-driven research and analysis on these same topics. And so the time savings and the cost savings in getting these responses within seconds versus doing traditional research aren't attractive at all if what you get is an incomplete response that threatens, the viability of your success as an attorney, that, violates rules, regarding diligence and competence to your clients, potentially puts you in a position having to answer some very difficult questions with judges and so forth. Okay, so let's talk about some strategies, and we're going to spend some time talking about some of these things versus, kind of trudging through some slides. I've already talked about retrieval augmented generative models. This is a question that you should be asking when you are evaluating AI legal research and analysis tools. Is your model a retrieval augmented generative model? And if it is, talk to me about the universe of data that your model is allowed to access. And it would be concerning if that universe is too small, which is probably why practical law in the Stanford survey generated incomplete responses 60% of the time. But it also can be a concern if it's too broad. The most obvious example of which would be a non-RAG model, which would be ChatGPT-4, right? It's out there drawing from everything that it can find on the internet as of whatever date the last release was by OpenAI. So the second solution, and this is where the science of AI meets the art and the intuition of human thought, and it's prompt engineering. If that's a term that's unfamiliar to some folks watching us today, it's basically the term that refers to how you ask AI questions, how you solicit results, how you ask it to go find information for you. Every one of the AI tools essentially has usually widgets that you can use for particular tasks that are pre-built, but then they've got just a general search query window that you're going to type your prompt into. And your ability to write that prompt effectively and potentially to iterate it through stages of solicitation is going to have everything to do with how successful you're going to be. So let me give you some examples of simple kind of first stage prompts. So let's say you've got a case where someone has fraudulently concealed the fact that they were embezzling money from a company, and your client discovers it after the statute of limitations, at least on the surface of things, has expired. And so you want to find out whether there's any possibility of making an equitable tolling argument based on a fraudulent concealment. And so a very, very simple prompt, but one that's going to be prone to a lot of the errors that we're talking about, is explain the notion of equitable tolling to me. Or write an argument, advocating for the equitable tolling of the statute of limitations when there's been fraudulent concealment. Now you might ask yourself, okay, what are the problems with that? And we'll talk about those here in a moment, but they have to do with defining scope, defining purpose, defining a particular jurisdiction potentially that you need to find information in, because what's happening in the state courts of California might have very little to do with what's going on in the PTO or the Delaware Chancery Courts or whatever the case may be, right?
Is AI, so for those of us, we know that we need to ask the right question to get the right result. Can we ask AI what's the right, say what we're kind of looking for, and then ask them what's the right prompt?
Actually, that's really, really insightful question, because one of the most successful ways I think to use AI is potentially to walk through getting a standard result, which might be like a legal memorandum on a particular topic, and color that up as much as you can with a specific factual scenario, limited in the ways that you want, and then go back in and ask it to identify assumptions that you've made or that it's made in conducting the analysis, or ask it to more or less tear apart the argument the way, an opposing counsel might tear it apart, or ask it to put itself in the role of a judge that's very skeptical and has typically ruled against this particular kind of argument, and ask you 3 to 5 questions that you would expect in oral argument, and then based on that, suggest non-obvious strategies to you to refine your argument and prepare yourself, to deal with counter arguments, which is really the last bullet point there. That's how we, I think, get the most out of AI, is to use it to criticize your use of it, or get it to criticize the product that it's created for you. And so you create, again, this generative model where you put it through a feedback loop in a really important way as you go. So let's get into a little bit more detail about prompt engineering. So we've already talked about the idea of scope and jurisdiction. So for instance, a prompt that deals with scope and jurisdiction might say, talk to me about cases that have been issued by the Delaware Chancery Court on issues of equitable tolling of statute of limitations in cases of fraudulent concealment, and that have been issued in the last 10 years, right? That's limited by scope. It's limited by jurisdiction. It's got a temporal limitation, which, we talk about here in the last bullet point, which is currency. And then a feedback loop for that, just to kind of take it one step further, would be for it, once you've gotten the summaries, ask it to go through and tell you whether or not there have been any other decisions that have commented on those prior decisions, basically doing an ad hoc version of shepherdizing the case, if you will. For those of us that are, older than, say, 45 and 20 years more in practice when we used to go to shepherds. And then ask it to summarize, the treatment, summarize any commentary on it, whether it's been criticized, overruled, rejected, so on and so forth.
But am I understanding correctly? Because earlier you said the scope of information that it'll have will be limited to its most recent update. So is it important to know what version or what update you're using? Because then that's the marker where the AI is not going to have new information after that date. So you might be missing something.
Yeah, and the system's gotten very automated, as we know. So LexisNexis, Thomson Reuters / Westlaw, the bigger players in the market are getting electronic reporting of decisions in virtually real time. And so, to the extent there's any lag in authorities, it is a matter of days at most. Right. It's not weeks or months. So you remember back in the day, I was in law school at a point in time where we still learned all of our research in the books. And so you would get the pocket part updates and so forth that you would go to, and you'd have to track the key numbers through to see whether or not there'd been any later treatment and so on and so forth. But even that system wouldn't give you, a case that had been decided in the last week in another jurisdiction. Obviously, we've progressed beyond that. And so AI, and particularly the AI legal tools that we're talking about, have close enough to real-time reporting that the currency challenges aren't as big a deal. But you might care as much about not having it go back and finding early 20th century cases, unless you happen to be dealing with an issue of water law or Native American law, to get into one of the areas that you spend a lot of time in. But it's that thought process, I guess, that needs to inform the prompt engineering. And so, as I talk to people about using AI tools in this way, I also think back to the days of physical law libraries, and I would get a research question from a partner as a young associate or even a law clerk before I was practicing. And it would be about a topic that I generally knew nothing about. And so what's the first thing you would do, like in that situation, like early in your career?
Well, I would have gone to the books.
Yeah, right. You'd probably go find a treatise, right?
Yeah, treatise.
Yep. So I wouldn't go directly to case law research. I'd probably go and try and figure out what this issue was about. So I'd go to a treatise, or sometimes I used to go back to like the West Digests and their key number system operated as essentially an outline of everything in the law. So if I had someone asking me to research an issue of failure of consideration, I would go find failure of consideration in the keynote system, and then I would see the broader context in which it exists, and that in turn would inform my understanding about how to frame up a search in Westlaw or Lexis, or how to go, to the digests and find cases.
Good memory.
Right? Yeah. So there is an application of these tools that's very, very much like that. And it starts with, the simplest form of query that we talked about, which is talk to me generally about the doctrine around equitable tolling of statute of limitations. And you get that. And then you say, now provide me a little bit more focused analysis of how fraudulent concealment, factors into that doctrine. And then once you have that understanding, then perhaps you plug into a fact scenario, right? So you give a paragraph synopsis of the factual scenario that you're going to be dealing with, and you say, given the following factual scenario, provide me a list of 5 cases that would tend to support a finding of equitable tolling, 5 cases that would suggest against it. And then you work your way in from there. It's still saving enormous amounts of time, but what it isn't doing, which you probably shouldn't do, is immediately jumping to draft me a product that I can then use to go file in the court case, right? So kind of turning back to the slide, requesting multiple authorities. And I even advocate sometimes for using multiple tools, AI research tools, and having them both run against each other and comparing products and things like that. It's an easy way to spot, disagreements or inconsistencies between the models. We've already talked about hierarchy of authorities. It's really important to understand, the most authoritative decisions. So a search hierarchy that focuses on jurisdictions and authorities might start out on a federal law question saying, are there any Supreme Court cases dealing with this doctrine? And then find me, at least 5 Circuit Court of Appeals cases for and against this topic, or that side to this particular Supreme Court case, and working your way down from there. And you can ask it to summarize the cases. Once you've identified a real case, the AI is very good at summarizing the holdings of that case for you and flagging for you the key passages that will particularly shed light, on the topic that you're looking at. It's also important to think about excluding authorities. I remember when I was starting out in legal research, particularly when they first started out with natural language searches, right? Before you had to use the incidence of this word within a certain number of words of this other word, maybe incorporating this key number. And then they moved to these searches, which are like what the whole world now understands as like a Google search, right? All kinds of false positives, citations to authorities that didn't matter to you, and so forth. So thinking through the parameters of your search in all those ways are helpful. Now, I want to talk to you about an experience I had yesterday when we're talking about prompt engineering, because really what this is about is getting the most effective use out of these AI tools. So in this symposium that I was in yesterday, on business topics, one of the guys illustrated a particular search structure that he found provided super helpful results for him. And basically, it was using search delimiters of context, role, interview, and analysis. And you do that by using hashtags, typically in ChatGPT. So it would be hashtag role hashtag, and that alerts the model that you're about to tell it a role that you want it to take. So here's the use case that he had. He had a client that was in the beauty industry that had a very aggressive strategic growth plan. And it contemplated 50% growth the first year and then ramping up to 300% growth over 3 years. And he was about to present it to his board, and he wanted to prepare himself to find out if there were gaps, find out if there were unfounded assumptions, kind of get to the bottom of what the board might think about this. So he assigned, gave the context, described the strategic plan, uploaded it into the LLM, and then he gave it a role, which was he wanted it to be a particularly aggressive and skeptical board member who was going to consume the strategic plan and who also had very deep industry experience in clean beauty, which was his business case. And then under interview, he said, ask me 5 questions, one at a time, that are designed to uncover gaps or false assumptions or over-aggressive, plans that I have in the strategic plan. Wait for my answer on each one, and then ask me the next. And so the model asked him 5 very tough questions. He typed in his best answers to them. And then the last thing he gave in the original engineered prompt was analysis. And it asked the model, after it had reviewed the strategic plan, adopted the role, and conducted the interview, to give him 3 to 5 non-obvious gaps or challenges that he needed to be prepared for in the strategic plan. And the results it gave him were transformative for that particular business client.
Yeah.
So it's not hard to think through how we could do a similar exercise in the law. Let me spitball one of those for you. So let's say that you are drafting a summary judgment motion on this equitable tolling argument that we've used as an example so far. You might go through the whole process of evaluating cases and so forth and mature your interaction with the AI model to the point where you're actually asking it to draft a brief for you. And it does. Legal memo or brief. We could use that same rubric of context, role, interview, and analysis to test drive an oral argument. So tell it to adopt the role, give it the brief, feed it back its brief, tell it that you're preparing for oral argument and that you've got an aggressive opposing party. Maybe you've already had it draft the opposing brief for you too, so that you can look at that, which you can do in seconds, maybe minutes at the most. And then you tell it to adopt the role of a judge of the Delaware Court of Chancery who has historically been very skeptical of and tended to reject arguments around equitable tolling of statutes of limitations. And then have it give you 5 oral argument questions that you might expect to be asked by this fictional judge. And then as a result of it, have it critique its own brief. Where are the hidden assumptions here? Where are the gaps in the analysis? Where am I most vulnerable to strong case law opposition to my particular argument? This is actually currently the gold standard of what AI models can do to help you provide quality legal representation with their assistance. Kind of transformative stuff. But it all starts with how you prompt the model to provide you information.
Is there any way to double check it, because you're really drilling home the importance of this prompt? Is there any way that we can check our prompts, or based on the result, know that we've gotten the right prompt for what we want? Or is it just one of those things that you have to kind of go in and experiment with?
Given the risks that we've already identified, completeness, hallucination, sycophancy, all these different things, you can basically ask AI to take your prompt and criticize it in terms of the risk of those 3 errors occurring. And it will actually help you be better at prompt engineering. But this is, as I kind of already said earlier in the discussion, this is kind of a product of science. I mean, you've got these suggested considerations, right, that you need to factor into your prompt engineering, but there's something that comes out of experience and intuition in terms of the art of doing it well. But in my experience, and not just in legal applications, using AI for a whole bunch of different purposes, AI is very good at telling you when you're using it well and when you're using it poorly. You just have to think to do it, and then it will help.
So how does this intersect, kind of going back to your earlier points about ethical consideration, how does this intersect with the duty of competence? Have you seen anything, typically as lawyers, we think about events like this, CLEs, or, we might go read an article or treatise to educate ourselves. Have you seen anything on the duty of competence about using AI to educate yourself?
So again, the information lags a little bit, the technology itself, but at last count, and this is in your written materials that we'll distribute to you electronically after the seminar. I've got about a 25-page packet for you. The states of California, Florida, New York, and the ABA have issued guidance on its use. And there are at least 25 federal districts that have now issued standing orders providing guidance on its use and its disclosure. And that is obviously the best place to go, is check to see if your jurisdiction actually has any particular guidance on it. But this is happening so quickly that oversight and regulation and so forth lags just inherently. And so it's left largely to kind of develop best practices around this. One of the things that you'll find in the materials packet that I've provided is a very simple AI adoption checklist and a set of sample protocols that you could consider using that will provide guidance about how to, and we'll talk about this here momentarily, how to make sure that you've got humans in the loop, HIPL, which is absolutely one of the safeguards against this going off the rails. Hybridizing human and automated tools, in the delivery of these different services and products, requiring a certain level of human checking to occur, whether we're talking about diligence, discovery, legal analysis, research and writing, that sort of thing. Speaking of which, we probably need to get this kind of popping along here. So let's turn to form-based practices here for a second. And I want to just kind of illustrate some of the areas that are particularly conducive to using AI-powered tools. So contract drafting, estate planning, real estate transactions, business formation and corporate filings, family law, immigration, bankruptcy, and not comprehensively in any of these areas, but there's certainly elements in each one of these practice areas where there are typically baseline documents that are used for different purposes, or court or agency prescribed forms that are used that can be tied to AI-powered intake and interview tools to populate, fields and create, semi-custom kinds of provisions in the different documents and so forth. So they all have applications. And as we'll see, as we turn to sort of the risks and weaknesses and the strategies, we've got to be careful at this stage of the development of these tools and relying on them too broadly and too heavily and without a human in the loop. Okay. So you're going to see some of the same themes pop up as we talk about form-based practices, and then as we turn in the last kind of phase of this conversation to document review, the same themes tend to pop up. So one of the big concerns is that these models aren't necessarily going to understand the context of the problems that you're providing for them. And for instance, let's just pick one of the form-based practices, real estate, for instance. Maybe you're being asked to draft a commercial lease, and there's a good form that exists in an AI-powered tool that can populate that document for you, at least the first draft of it. There's a considerable amount of nuance in every client's situation, unless it's literally a turnkey rental of a storefront in a strip mall where it's sort of a one-size-fits-all approach. But AI is not necessarily going to appreciate that. And so there are weaknesses there that lead to problems with accuracy as well. The same ethical risks that we've already talked about, lack of human involvement, the risk of hallucinations, confidentiality risks exist if you're using an AI tool to pump sensitive client information into a form. Data security and privacy risks, as we've talked about. In form-based practices, there's another issue that comes up a lot, which has to do with compliance and regulatory risks. The law tends to change and the regulations change. And so if you have your own forms that you have developed in one of the, castle and moat models, like a Jasper or Claude style model, you've got to be responsible for regulatory and compliance updates. If you're using, a turnkey kind of a solution, a commercial solution that's probably a SaaS-based model, it's important for you to be aware of how frequently they're updating. And if you're aware as a professional in a particular regulated area that there's been new guidance or new rules, it's incumbent on us to follow up with our vendor and make sure that the forms are compliant. And if they're not, when will they be? And if you're using it in the interim, making sure that you've got maybe even a stronger presence of a human in the loop to make sure that once that first draft is generated, which might still be a significant cost savings and time savings, that it's being looked at, with an educated eye to make sure that it is actually compliant. And then we've talked a little bit about this as well, client experience and trust issues. So as much as my experience has generally been that clients appreciate the use of AI, there are certainly clients out there that would either be troubled by your use of an AI-powered tool to generate all those forms, or it would cause trust issues with how you're billing your time because they're going to have a perception that potentially you're just pushing a button and the documents are coming out and they don't understand how you're subsequently billing 2 or 3 hours time. Not hard for us to understand that because you're probably going through them as a good attorney and making sure that they fit, and you would have otherwise spent 7 or 8 hours potentially doing that. But as I've said, there are also clients that are going to have their own AI use policies, and they're going to want to make sure that you're sensitive to being compliant with their own internal policies. And there is enough out there in terms of war stories, parades of horribles, whatever we want to call it, that some clients will need a little bit of hand-holding and explanation to be comfortable that what's being generated by an AI model is reliable for them when it's potentially a bet the farm, issue that you're working on for them. Okay, so how do we mitigate those risks, augment those weaknesses? So I've already talked about humans in the loop, HITL. You're going to see in the written materials I've included, and we're not touching on it here, there's a glossary of AI terms that get used commonly with AI and some more particularly with legal AI, and HITL is a very common reference when we're talking about AI. So the solutions there include hybridizing workflows. So figuring out where you can plug AI in to create the efficiencies that you're looking for, to standardize things so that you don't have spurious versions of things running around and so forth, but intersperse those with actual human stops where someone that is capable and competent at a sufficient level of experience and or supervised appropriately by someone who is, have eyes on product and are evaluating it. And I can't overemphasize this enough. Establishing checklists and setting up systems and processes. So once you understand and want to take advantage of the efficiencies that AI can provide, thinking kind of critically through, okay, how will we implement it, to start with? How might we modify that over time once we get comfortable that things are running well, but still making sure that you've got stops in your process where a human will put eyes on it and will sign off on something meeting the standards at that stage, and sort of objectivizing what those standards are, whether we're talking about forms or legal briefs and so forth. So the other thing that I also can't emphasize enough is that, like any other tool or process that you're going to use in a law practice, and the larger the law practice or the law firm, the more this becomes an issue, you need to have a strong educational foundation in how these tools can be used, how they can be used ethically, how they need to be disclosed to clients. The attorneys who are going to use these tools need to be aware of the risks and the weaknesses. They need to learn how to spot hallucinations in AI results the same way we spend time educating them how to spot phishing expeditions with email. or malware risks, as they're having files sent to them and so forth, which, we've all recognized those risks and generally taken steps to try and make sure the people that we work with are sensitive to them. Obviously, we've got to have our eyes on data security and confidentiality. And I will tell you from an insurance perspective, given how quickly things are happening in this space right now, your malpractice insurers are going to ask questions about your use of AI. And more generally, your data security and your system viability and so forth. And while there is coverage that's available for these kinds of things, think of just hacking breaches and stuff. But now compound that with, your proactive use of AI tools. You have to have your eyes on this. And it probably doesn't hurt for particularly larger law firms to spend a little bit of time talking to their insurer. And I know, talking anecdotally before we started today, that one of the participants today talked about their insurer actually coming in and presenting on some of these issues because it's a concern for them too. We already talked about compliance and regulatory issues, making sure that you're on regular update cycles, and then just maintaining a focus on client experience and trust. And, much as I'm going to disclose some things about the use of AI for this at the end of the presentation today, I think, again, telling our clients that we're using it and how we're using it is important for them to feel confident that they're getting what they're paying for. Okay, we're kind of winding down on time, so I'm going to kind of fly through this last bit, which is talking about discovery and diligence. So really what we're talking about here is getting through large stacks of documents. And that has applications both in litigation, in the discovery process. It has application in regulatory and compliance practices and contract reviews. And it has applications in diligence relating to corporate transactions and so forth as well. Pretty much the same concerns. I will say this, in the written materials, the benefits, the risks, and the strategies are broken up by essentially corporate diligence practices and litigation discovery practices, because there are some nuanced differences that I think it makes sense to be aware of. But we're going to kind of cover them together here in the presentation today. So benefits, a lot of these are Captain Obvious kind of stuff. So obviously faster and more efficient document review, contract review, diligence, and there's cost savings, whether those are savings in OpEx for your law firm or they're savings that are going to be passed on in terms of billable hours. This does make things a lot more conducive to flat fee and value-driven billing models as well. I'm not going to spend a lot of time on that, but once you understand how much more quickly you can get through an exercise that might have taken 3 or 4 professionals, days or weeks, it does prompt a lot of thinking about how you bill for services. Subject to the risks we've talked about incomplete results and so forth, and sycophancy and hallucinations. Generally speaking, there is improved accuracy in processing documents, classifying them, creating databases with key data points that you might want. So for example, in large e-discovery projects, you might want to create a database of all the emails by sender, recipient, dates, times, subjects, the incidence of certain keywords that are relevant to your litigation. And then once you've had it database those for them, then you can use further AI tools to go in, eliminate duplicates, do sensitivity analysis, which is essentially trying to pick out emotion from the communications that they've databased. And that process using AI is a lot less susceptible to human error and bias than direct human review of those documents would typically be. In the process of diligence or compliance and regulatory review, studies have demonstrated that there's enhanced risk identification. So for example, if you're charged with reviewing all of the vendor contracts for a large company, and you have already uploaded into the AI model the vendor standards and some information about the kinds of contract provisions that are either acceptable or not acceptable. Maybe they have to do with signing authority. Maybe they have to do with budgets, different things that could come up in those contexts. AI is very good at finding the things that don't fit the box that you've identified for it. Now, the best practice use of that is going to be to have it flag the things and then put a human in the loop to actually look at the exceptions and determine whether they really are exceptions. And then the gold standard for that is once you've had the human in the loop and you've subjectively analyzed those potential hits, then going back in a feedback loop and informing your AI model of where it was right and where it was wrong, analyzing where it made the mistakes based on potentially some of the instructions that you've given it. And so I've had large scale practical and thought exercise interactions with AI models where I've sensed that I didn't give it clear enough information or it gave me something that didn't work. I've literally explained to it like I was having a conversation where something didn't fit my expectations, and then asked it to go back and re-perform the task again and provide me with a revised result and highlight for me the differences that came out of the revision with my second, third, fourth set of instructions that I've given. So it's important to think about the process that way. Similarly, there's enhanced privilege and confidentiality detection compared to, say, human review. And I would add to this also, confidentiality can mean a lot of different things, but one particular application might be the existence of proprietary information that you could get a protective order for in a discovery dispute. And so if you identify the things that are sensitive, it's pretty good at picking up the places where it might inadvertently be disclosed. If you're using the right tools, and if you tell it to do it, these AI models are very good at creating audit logs. In other words, creating the breadcrumb trail that explains exactly what was done. And that's important because one of the risks we'll talk about on the next slide is the black box problem, which is that it's difficult sometimes to understand how these AI models are doing what they're doing. And so having it explain what it's done after or as it's done it is an important benefit. And then there are integrations with business intelligence tools. I've already kind of alluded to this with Microsoft BI and so forth. All right, so I've been told it's time to leave the stage. So I'll get you a copy of the deck here. Again, the themes are very similar, and we've already kind of alluded to some of them, but humans in the loop, teaching the model, cross-checking and validating, all the things that we've talked about before have the same application here for discovery and diligence. So I will leave it with that.
And I think you were going to share something with us about how you created.
Yeah, so, I'm like a kid in a candy shop with this AI stuff. I'm not going to lie. And to say that I'm an expert on it is actually doing me way more credit than I deserve. But I'm deep into understanding how it works. And so I actually, in the spirit of full disclosure and transparency, will tell you that I created all the presentation materials, the deck, and everything using AI, and was able to accomplish that with some good conceptual foundation about what I wanted to accomplish, was able to accomplish all of that in about 6 hours. And in comparison, I teach a lot of CLE, and I teach at the law school level as well. And the roughest approximation I can give you is that it was probably an exercise that would have required a 3 or 4x of that time typically for me to prepare things. So far from perfect. You'll get in the written materials, and you may even see the fingerprints here and there of ChatGPT. But you can accomplish a lot with these tools. And this is proof of that.
Yes, Dan shared with me last night that he had used generative AI for the materials today, and it's been hard not to let the cat out of the bag during an excellent presentation.
Thank you.
So big thank you to Dan for just a really great presentation. And I'm sure that there's even more that we can cover. And so we'll look at that for future CLEs. And for those of you who are here and are thinking, gosh, you know, I want to go back and look at that again. We'll have this presentation loaded up on our place where we have CLE classes at the S.J. Quinney College of Law for you to look at in the future. And big thank you to Dayton. Thank you so much.
Thank you.
Shane McGoach, everyone. Thank you. That was great.